Hello friends, today discuss this topic offshore accident layers in Austin TX. Hiring the right offshore accident layer is important if your family member has been hurt while working as a dock worker, seaman, or oil and gas industry employee. These jobs are very difficult and dangerous. You are really on your employer and other responsible parties to put in safety measures and make sure they are followed. Unfortunately, too many companies do not protect their workers. The attorneys at the Wilden legal group will uncover any negligence that contribute to your injuries. We will fight to make sure you receive the money you need to pay your bills and move forward with your life. Call our Houston office at for a free consultation. What damages can I get for my maritime worker injuries? As your offshore injury lawyer, our goal is to make sure that whoever is responsible is held accountable. We will make sure you receive the money you need to recover from your injuries and pay your bills. Damages you may be entitled to fall into two main categories: economic and non-economic. Economic damages are pretty straightforward. They may include money for medical expenses, hospital bills, medical devices, and mobility aids, medication copies, therapy, and rehabilitation costs. Money for expected future medical expenses, wigs lost due to your recovery, vocational rehabilitation, loss of earning capacity if your injuries will impact your ability to work over the long term or permanently. Not all losses are clear cut or obvious. Of course, non economic damages are meant to compensate you for emotional pain and suffering, anxiety, and lower quality of life. In some cases of extreme negligence, you may have to the right punitive damages. They are designed to punish the plaintiff. If you are qualified as a seaman under the Jones Act, you may be eligible for benefits called maintenance and cure. Maintenance compensates the worker for the cost of room and board as the recover. Cure is the cost of the injured seaman's medical expenses along with the transportation required to get treatment. Once the seaman reaches maximum medical improvement, maintenance and cure benefits and maximum medical improvement, the person is as healthy they are going to get even if you're not fully cured. What is the Jones Act and does it apply to my case? The Jones Act is also called the Merchant Marine Act of 1920. It is a federal law that gives someone certain protection. It allows them to sue their employer if they are injured on the job due to employee negligence. If you spend most of your time working on boats or vessel in navigation, you may be considered a seaman. If you work on a vessel as a sailor, deckhand, diver, engineer, driller, mechanic, captain, maid, steward, cook, freshman, or in another capacity, you may meet the definition of seaman. If you do fit the definition of seaman under the law, you are not eligible for workers' compensation. You must seek compensation for your injuries through the Jones Act. Under the Jones Act, employers of seamen are injured to provide a responsibility safe work environment and maintain the vessel in responsibility safe condition. The Jones Act holds employees liable even if the injured worker contributed to the accident in some way. Examples of unsafe conditions that employees may be liable for include broken or poorly maintained equipment, oil or grease on the deck, lack of proper training, lack of proper equipment, negligence of a co-worker, assault by a co-worker, failure to provide sufficient manpower, and failure to provide warning about hazards known to the employer. Generally, you must file your Jones Act suit within their 3 years of the date of the accident. directly within attorney to understand the statute of limitation and any other deadlines that apply to your claim. Thank you for watching this video.